This is the February 26, 2013 meeting of the Town of Fairfield Town Plan and Zoning Commission. First item on the agenda, and I want to begin, before I start the meeting, I just want to, sir, I just want to address the public that's here. There was an item originally scheduled for tonight, 185 Thorpe Street. That is not going to be heard this evening. There was an error made by the Connecticut Post in publishing the notice of tonight's meeting. They had the wrong date for the meeting in the newspaper notice, and because of that, we're statutorily prohibited from conducting the hearing tonight. So anyone who is here on 185 Thorpe Street, there will not be a public hearing on that tonight. The hearing will take place March 26, 2013. We apologize, but the notice that went in the paper, which is required by law, had the wrong date put in by the Post. They actually did not put today's date in. They put, I believe, last week's date in. Yeah, I can't address the public, but the notice, you can talk to the staff, which is sitting on my left. They can answer that question, sir. They'll be able to answer that for you. Again, I'm sorry to the commissioners, too. We have you here early tonight, thinking it would be a long agenda on Thorpe Street, and we just found out that the paper published the wrong date on it. So, what we will have for public hearing tonight for the members of the public that are here are two matters: 893 Sasco Hill Road, which has been continued from January 8th and January 22nd when there was testimony. And we will be continuing 452 Brookside Drive. There will be a further hearing on that, which began on January 22nd as well. So the first item on the agenda are meeting minutes from January 22nd, 2013. Is there a motion on those? Motion on the minutes?
Motion to approve.
Thank you. Commissioner Wagner's moved to approve. Is there a second?
Second.
Thank you. Commissioner Jacobson has seconded. Are there any additions, deletions, or corrections to those minutes?
Yes, sir.
Hearing none, all in favor of the minutes as presented signify by saying aye. Aye. Opposed, abstentions? And Commissioner Wagner moved and Commissioner Jacobson seconded. And it was you approved unanimously. Next item, 705 Villa Avenue, request of Langen Engineering for a 100% release of a $77,945 bond pertaining to site improvements for Stop and Shop Gas in a designed commercial district. Mr. Wendt?
All right, we skipped item B, but we can.
I'm sorry, I
we can
apologize.
do
Let me
this.
go back to, we'll go back to B, that's fine. Item B, 65 Commerce Drive, request of UAG Fairfield LLC for 100% release of a $36,360 bond pertaining to site improvements for expanded parking in a design industrial district.
Okay, back in September, this commission approved a zoning compliance application. You may recall Mercedes-Benz of Fairfield is at that location, and then in a previous application they expanded the parking lot. This was a second expansion of the parking lot onto a portion of the property that was the former Laidlaw Bus Company lot. That's all been done. You have a report from the previous packet that engineering and is all set, recommending 100% release.
Thank you, Mr. Wendt. Is there a motion on this?
Motion to approve.
Thank you. Commissioner Jacobs has moved to approve the release of bond. Is there a second?
I'll second it, Mr. Chairman.
Thank you. Commissioner Kennelly has seconded. Is there any discussion? Hearing none, all in favor of the release 100% of a $36,360 bond pertaining to site improvements for expanded parking at 65 Commerce Drive signify by saying aye. Aye. Opposed, abstentions, carries unanimously. Next item, 705 Villa Avenue, request of Langen Engineering for 100% release of a $77,945 bond pertaining to site improvements for Stop and Shop Gas in a design commercial district. Mr. Wendt?
This was an April of 2012 approval to redo the gas station there in the corner of Villa and Tungus Hill to Stop and Shop Gas. Again, you have a report in the packet that the engineering is satisfied that 100% of the work is done and concurs with the request.
Thank you, Mr. Wendt. Is there a motion on this?
I'll move to approve, Mr. Chairman.
Thank you. Commissioner Kennelly has moved. Is there a second?
Second.
Commissioner Suter has seconded. Any discussion? Hearing none, all in favor of 100% release of bond, 705 Villa Avenue, in the amount of $77,945 pertaining to site improvements at the Stop and Shop gas station, signify by saying aye.
Aye.
Aye. Opposed, abstentions. Item carries unanimously. I saw a few folks come in late. I'll just address the public here. If you're here for 185 Thorpe Street, there's not going to be a public hearing this evening. Unfortunately, the Connecticut Post, when they ran the notice in the newspaper, they published the wrong date for tonight's hearing. So you may know about it from the website or other sources, but the wrong official notice was published under the statute by the paper, so it's been continued to March 26th, 2013.
Yeah, Mr. Chair, there was a fairly sizable direct mailing to the public, because since it's a zone change within 500 feet, they got the correct notice,
Correct.
but unfortunately, the publication notice was incorrect.
And because of that, we cannot have the hearing, and the applicant is not present this evening. Thank you, Mr. Nguyen. Next item, Affordable Housing Plan Update. Request of Mark Barnhart for review of a grant resolution.
You have in your packet an email and a draft resolution. The Affordable Housing Committee has been tasked with updating the town's affordable housing plan. There is a grant application available to potentially assist in that endeavor, which would require the approval from this commission to make that application. So there's a draft resolution prepared by Mr. Barnhart, who is here if you have any questions. But I think he's simply seeking your approval to go forward with the grant application.
Sure,
And approve the draft resolution.
Thank you. I'll entertain a motion first on the resolution, and then we can have discussion and/or call on Mr. Barnhart. Is there a motion? And the resolution is attached to the packet in a February 12th email from Mr. Devanchik. Is there a motion?
Motion approved.
Thank you. Commissioner Wagner's moved to approve. Is there a second? Commissioner Jacobs has seconded. Is there any discussion or questions of Mr. Barnhart, our Director of Community and Economic Development?
Well, as I understand it, the resolution is simply to authorize you to seek the grant from the state, correct? Sorry.
Yes, that's correct. The resolution, this application would go to the Office of Policy and Management. It does require the endorsement or support of both the Plan and Zoning Commission as well as the representative town meeting. So your support would be greatly appreciated.
Very good. Thank you. Are there any further questions or comments by any member of the Commission? Commissioner Sutter.
I think the issue of affordable housing is very...
It might be open.
How's that? Okay. I think the issue of affordable housing is an important one and has been the subject of one or more hearings in the past year, actually several hearings, particularly as relates to the Homeland Opportunity District. I think it's a very good time to examine the whole subject in depth, and I fully support this effort.
Thank you, Commissioner Sutter. Any other member of the Commission have any comments? Hearing none, all in favor of the resolution, and specifically I'll read the resolution into the record. Whereas the Board of Selectmen at its meeting of February 6, 2013, tasked the Affordable Housing Committee to prepare an update to the Town of Fairfield's Affordable Housing Plan, and whereas the Affordable Housing Committee intends to seek grant funding from the State Office of Policy and Management for such assistance as may be available to develop said update to the Affordable Housing Plan. Now, therefore, be it resolved that the Town Plan and Zoning Commission of the Town of Fairfield hereby endorses submission of a pre-development grant application for assistance under the Housing for Economic Growth Program as referenced in Section 8-13 of the Connecticut General Statutes. All in favor of this resolution signify by saying aye.
Aye.
Opposed? Abstentions? Resolution carries unanimously. Thank you, Mr. Barnhart. Next item, new application to recommend to public hearing, 85 Mill Plain Road, zoning compliance application of 85 Pond Mill LLC for indoor recreation use with request for reduced parking and review of overall parking, design industrial district. Mr. Wen.
You may recall that a couple of months ago, the Pond Mill folks appeared before this commission, or actually didn't appear, they presented some materials to you through a request, and which was denied at that time because A, you didn't feel there was enough background information, and secondly, there wasn't an accompanying application for an actual user. They have an actual user now, so they are making application both for that user and for another opportunity or an opportunity to dialogue on the overall parking count for the site.
Thank you, Mr. Wen.
And it does require hearing.
Thank you, Mr. Wen. Is there a motion on this item?
I'll move to approve.
Commissioner Kennelly has moved to recommend a public hearing. Is there a second?
Second.
Thank you. Commissioner Jacobson has seconded. Is any discussion? Hearing none, all in favor of moving to public hearing, 85 Mill Plain Road, zoning compliance application of 85 Pond Mill LLC for indoor recreation use with request for reduced parking and review of overall parking in a design industrial district, signify by saying aye.
Aye.
Opposed, abstentions, item carries unanimously. Excuse me, we have one item under old business, 289 Hunyadi Avenue, subdivision application of 289 Hunyadi LLC for 2 lots in a B zone. Public hearing was January 22nd, 2013. Expiration date is March 28, 2013. The commissioners present: Leclerc, Barretts, Jacobs, Jacobson, Suter, Wagner, Alessi, Neely, and Parker. On this item, I would suggest, before we go too far, and inform the commission that I received a correspondence this morning from the town attorney regarding this application and an issue involving a possible one free cut of the lot that may be eligible for, that may lead to the withdrawal of this application from the commission. And there is going to require some further discussion, I think, by the town attorney and myself. So I would suggest, Mr. Devanchik could report, but I would suggest we may want to consider tabling this item to the next meeting. Mr. Devanchik?
No, we're requesting a table, just to give you some time to review it.
I'll make a motion to move to table the item.
Thank you, Commissioner Wagner. Is there a second?
I'll second.
Thank you, Commissioner Kennelly is seconded. Is there any discussion on the motion to table this item? Hearing none, all in favor of the motion to table 289 Hunyadi Avenue subdivision application of 289 Hunyadi LLC, signify by saying aye.
Aye.
Opposed, abstentions. Item is laid on the table. We have 2 compliance applications. First is 2189 Blackrock Turnpike, application of Turnpike Properties to establish an indoor recreation facility in a portion of an existing building in a designed commercial district. Mr. Wendt?
Okay, both this item and the next item, the materials for these 2 applications were sent in your February 12th packet. If you don't have that material, I can try to share what I have here. The first one, 2189 Blackrock Turnpike, is the Gap Old Navy building, for lack of a better name. At the far left-hand side is a business that's been there for quite some time, Ritz Camera. They are leaving, and the proposal is to replace that with a fitness use. It's a fairly modest-sized workout facility called Coco Fit Club. It's before you because we classify that as an indoor recreational facility rather than retail, but the parking calculation is the same for both. I do have a copy of the floor plan if you don't have it from your February 12th meeting, which will because of the school is closed. But it's all interior fit up, and the parking is the same as that for the retail space.
And there's no expansion of the building of any type, correct?
That's correct.
Thank you. Is there a motion on this item?
Motion to approve.
Commissioner Jacobs has moved to approve. Is there a second?
Second.
Thank you. Commissioner Suter has seconded. Any discussion? Commissioner Suter.
Yeah. I checked the regs, and it seems to me that this use is permitted under 12.4.8, so I support it.
Thank you, Commissioner Suter. Is there any further discussion by any member of the commission? Hearing none, all in favor of the compliance application of 2189 Blackrock Turnpike, application of Turnpike Properties to establish an indoor recreation facility in a portion of an existing building, designed commercial district, signify by saying aye. Aye. Opposed, abstentions. Item carries unanimously. Next item, 2047 Post Road, application of Matt Walsh for an overall sign plan in a designed commercial district. Mr. Wendt?
Okay, you may recall that this application was denied by this commission a couple of meetings ago due to lack of clarity in the method of illumination of the sign. If you don't have your packet from the 12th, I can pass this along. There are 2 wall signs proposed. One is a channel letter sign facing, and again, well, just to back up a second, we're talking about the new renovated gas station convenience store on the corner of South Pine Creek Road and Post Road. There is an internally illuminated channel letter sign facing the interior of the site with the name of the business called Wheels, and then on the side of the building, which is facing the Post Road, there's a combined side-by-side sign that totals 3 by 12 for identifying Blimpies and Nathan's, which is within inside the convenience store. There was some concern about the method of illumination, and if you don't have it, I'll pass this along. They show both a daytime and a nighttime simulation and their graphics here to confirm that, as required by our regulations, only the copy can illuminate, not the background of the sign.
So they've confirmed then that their proposed sign is in full compliance with our regulations?
Correct. That was the concern
Correct.
that you guys had before, and if you don't have it, I'll pass that along.
We'll let the commissioners take a look at that as we pass it along. Is there a motion on this while we are taking a look at it? So we can discuss it.
I'll make a motion.
To approve.
Mr. Chairman, to approve.
Commissioner Kennelly has moved to approve. Is there a second?
I'll second.
Commissioner Jacobson is seconded. We'll just pass the revised drawings around here. Commissioner Neely, do you need to see this too, or do you have one? Do you want to see this too? I'll have to come all the way around. Okay.
In addition to the drawings that are there, there is a written narrative that we had from the last meeting that, you know, that emphasizes that the background of each of those panels is opaque, so it will not illuminate.
And these signs are on the side of the building?
The building front facade that has the wheels that looks at the front of the building faces South Pine Creek Road. So the gable end of the
Lindy's
building.
and Nathan's are on the...
What's your-
That's the side that faces the post
That's
road.
the
the
side
front?
that faces the post road. The
That's
way
the
they've
post
turned
road.
the building, the peak of the roof, the A is what you visualize, what you see from the post road. Remember the configuration, it's not the same configuration as the old building.
It
They
isn't,
have it,
yeah.
I want
If
to
you turn,
walk
if you,
sideways.
Jim, if you flip that page
Right.
to the front,
That's
that
what you see.
elevation faces South Pine Creek Road. The wall on the left of that
Is
image
facing the post, right?
is the following page, facing the
Okay.
post road.
So what would be what would be...
As you're coming down the post road into the center of town of Fairfield, this is where
I
the
get
pumps
it.
are, this is the front door, the Flumpies and the Nathans are on this side.
Right.
Okay. Now, the reason I asked that question is because, you know, the neighbors behind there are struggling with dealing with the larger structure, you know, I mean, you know what I'm saying? I've heard, just so you know, I've been approached, you know, obviously it's not here, but I've been approached by individuals concerned who live there, you know, in the course of being in the supermarket or something, who are, you know, concerned about the changes. So, these signs, though, are allowed, I guess, in terms of their illumination because of the fact that they're opaque for the surrounding
Right,
line.
but neither of those face those.
They don't face the
residential
back, obviously, but I'm saying, I'm concerned about what's on the side, because some of that spillover to some extent is going to be part of it. But I guess with their overall lighting plan, this is more to advertise than it is to illuminate, really. The lights on the site are already really what the issue
Yeah,
is with
the lighting is within a cabinet in both instances, so it's not really gonna, you'll see it, but it's not gonna project beyond the.
Right.
And I remember when we first discussed it, part of the issue was those condos are located in a commercial district, and they got a
Yeah.
variance to build
They did.
adjacent to a gas station to begin with,
No,
which was part of the issue.
absolutely true. Absolutely true. It's just, you know, they're
So
struggling with
we can't- I
change.
know.
That's what I'm saying, is you had a fairly low-key, sleepy, you know, development there before, and the new facility is, you know, bigger, brighter, so. But these are advertising.
And they're internally
These
illuminated, so they're
are
not-
advertising signs. It's not as though this is a pitch black with these are the signs of the main illumination. It's actually the various lights on the property, which are
I believe they're-
already approved.
And I believe they're having it recessed in the canopy as
Right.
the stations have
So
been.
this isn't, to a great extent, going to really change the amount of illumination already on the site.
It would probably make it less, if anything,
Right.
eliminating those pole lights they had
Right.
before.
Okay.
Is there any questions or further discussion by any member of the commission? Hearing none, all in favor of application of Matt Walsh for overall sign plan at 2047 Post Road, signify by saying aye.
Aye.
Aye. Opposed, abstentions. That concludes the executive session of the meeting. Now we're going to go to public hearing for the public that's here. We have two items on public hearing this evening. The first is 893 Sasco Hill Road, a re-subdivision application, followed by 452 Brookside Drive. We'll stand in brief recess while we reconfigure the room. And I'd just like to welcome the 6 Boy Scouts from Troop 82, First Church. or working on your citizenship in the Community Merit Badge. Welcome, and I'll send a few of the commissioners over to welcome you and tell you what we'll be listening to during the brief recess. So we stand in brief recess. Thank you.
What was that?
These kids, they're from a local pack. They're studying, they're getting their government badge. Happy as
You're gonna make
a
me
great
jealous
Cub
now?
Scout.
Yeah. That's where he sits, huh? And that's yeah. It's streaming.
We're back in session again. This is the February 26th, 2013 meeting of the Town of Fairfield Town Plan and Zoning Commission. We're now going to be beginning the public hearing portion of our meeting. I'd note for the first item on public hearing, 893 Sasco Hill Road, Commissioner Suter is recusing himself from this particular item and has removed himself from the table. Again, I'd like to welcome all the Boy Scouts from Troop 82 who are here tonight to observe a public meeting in action for their citizenship in the community merit badge that they're working on. Welcome, gentlemen. I'd also like to alert the public, if anyone is here on 185 Thorpe Street, that application, it will not be heard tonight, as I announced earlier. Unfortunately, while the notices that were mailed to the residences in the area have the correct date on them, the notice that was published in the Connecticut Post unfortunately, the Post put the wrong date of hearing on the notice, and because of that, we have a statutory deficit defect, and we cannot conduct the hearing tonight. So if anyone's here on 185 Thorpe Street, the public hearing will be March 26, 2013. They're going to republish the notice in the newspaper correctly. So the two items on, the first is 893 Sasco Hill Road, 452 Brookside Drive subdivision is the second application. To remind you where we are on 893 Sasco Hill Road, Attorney Green had presented some evidence and testimony, commentary regarding the driveway or street configuration, and Attorney Fitzpatrick was going to address that, I believe, now. So I'm going to call on Attorney Fitzpatrick and welcome you.
Mr. Chairman, members of the Commission, for the record, my name is Bill Fitzpatrick. I'm an attorney in Fairfield with the law firm of Fitzpatrick, Frey & Bologna. We have offices at 1150 Post Road. I'm here representing the McDonald's relative to their subdivision application on Sasco Hill Road. I certainly appreciate the opportunity to address the points raised by Attorney Green at the last hearing. The order of the presentation tonight will be relatively simple. I will first provide a regulation section by regulation section analysis of the relevant zoning and subdivision regulations. If the scouts have any difficult sleeping, After that, I am certain they'll be able to rest their heads. I will then introduce Mr. Michael Paterla of the Huntington Company to outline several examples of rear lots approved by this commission in the Residence AA and the Residence AAA zones. I will then conclude. I'd like to first start by handing out a zoning and subdivision regulatory analysis, if I might, Mr. Chairman.
Does Attorney Green have a copy of this?
Yeah, Your Honor.
Yes,
Your Honor.
yes.
Honestly, I've been in court all day, Your Honor, and
wishes.
I do hold you in the highest respect, but I do recognize that you're chairman, but I was in court all day, and I
Yes,
didn't.
Mr. Green, Attorney Green.
Mr. Chairman, I have in fact been handed this analysis, and as I had indicated when we last were before the commission, it was my understanding that no new materials were going to be submitted, and I believe that may have been something that the chairman may have raised, and it appears that there is a detailed analysis that I just got 5 minutes ago, and as you're aware, the rules of this commission is governed by the rules of fundamental fairness under Connecticut law, and I would suggest that to the extent that Mr. Fitzpatrick continues to hand out this material, that that my clients and I be provided an opportunity to submit a written response to the commission that addresses the claims by Attorney Fitzpatrick, and having not had an opportunity to read this document, I don't know exactly what they would be, but it seems to me that that would be fair.
Yeah, as I indicated at the last hearing, there would be no new materials submitted, meaning no new areas that we will be going into except for this rather narrow discussion regarding the regulations and the width of the driveways to the lots. And I believe, Mr. Fitzpatrick, that's what this is addressing for us. Is that correct?
If I might address as well, Mr. Chairman, Mr. Chairman, that is precisely what it addresses. And what this is essentially my oral argument put on a piece of paper. I don't know how that can be construed to be new information. That's the chairman's call, not mine, but that would be my position on it.
Well, having not had an opportunity to read it, and certainly I take Attorney Fitzpatrick at his word, but having not had an opportunity to even read the document, I would submit that I can't assess that.
All right, well, let's let Attorney Fitzpatrick go first, then I'll address that. I'll issue a ruling on that at the appropriate time.
So what I'd like to do, Mr. Chairman, is to first just take a quick look at the site, then go through the analysis I've given you. These are the two lots which are proposed to be subdivided. This is the existing home. This is the proposed lot. This is the charred parcel back here. There are two homes on the charred parcel, an older home and a newer home. The proposed lot line between the existing home and the proposed lot is as follows. As a result, this lot, proposed lot 2, will not utilize the existing driveway at all. It will have its own driveway directly to Sasko Hill Road.
So your proposed lot line, when you're indicating on the map, is actually below that orange area?
It is, yeah, that's correct. The charred parcel has a 20-foot easement legally running to Sasko Hill Road. I referenced that here. That is over the property of McDonald. The McDonald property owns the entire 40-foot width from here to here. The charred property has an easement over the northerly, if you will, 20 feet along here.
That's not in writing anywhere, right?
Oh, it certainly is.
It is.
It's in the documentation, and part of which I submitted last time, which
Right.
includes the deeds.
So, because I remember last time there was the continuation from the first meeting, from the first hearing to the second hearing, there was a request from Attorney Green for you to submit any written easements, right?
And I submitted deeds that referenced those easements.
Okay, so that was in the record previously?
Correct.
Okay.
Correct. So with this context, if I can look at this, if you would, section by section, because it does get a little confusing, I wanted to take as careful look as I could. The first text, what I have done is I've given you two pieces. This is just the smaller, is simply a Xerox of the relevant portion of the zoning regulations and subdivision regulations, so that in the event I misstate any text, you can catch me on it.
But you're not going to do that.
But I wouldn't do that. Certainly not intentionally. I'm not a good typist. The first text is from the zoning regulations and is a definition of rear lot, and outlines that it doesn't have frontage on an improved public street, or if it does, is not of such shape that some portion of the square is located within the area required for setback from such street. This is the definition of rear lot from the zoning regulations. The charred property back here does not have any frontage on an improved public street. It is a rear lot. McDonald Home has frontage on a public street once it's cut off, but no portion of its square is within the street setback from Sasko Hill Road, so that it too will be a rear lot. If you go to page 2, and then I go on to note that the building lot to be created is not a rear lot because it has frontage on a public street, and its square is within the street setback. Section 2.7, I did this section literally sentence by sentence because it's a lengthy section. The first section states that no rear lot, as defined in the regs, shall be used in various zones for anything other than a farm building. This prohibition is inapplicable to our property, since our property is not in one of the zones set forth in that section, in that sentence. Our property is residence AAA, and rear lots are permitted in AAA. If you look at the second sentence at the bottom of the page, it notes that no lot shall be used or occupied for a structure other than a farm building unless such lot has a frontage of 20 feet or more in width on an improved public street, or such lot has an unobstructed easement of access or private way, which is everywhere 20 feet or more in width to an improved public street. This section therefore confirms that the charred property can be used for residential purposes, as it is today, since it has an unobstructed easement of access, which is everywhere 20 feet or more in width to an improved public street. And then I referenced the deed which I submitted last time.
No,
The
can I stop
Yes.
So when we spoke last time, we were talking about 2 homes on that shard property, right?
That's true.
And at one point, there was a question as to whether the access going down was maintained at 20 feet, right? Whether the second home on the lower portion was also, yeah.
This home.
Nope,
Right here.
that one, yes,
This one.
where the red dot is.
Right.
Yes. This home and this home
Yeah.
are on the same parcel of property.
Right,
That property has a 20-foot easement of access to Sasko Hill Road in the land records, included basically in the yellow.
okay. So last time, there was a question as to whether the lower portion of the yellow was in fact 20 feet wide, or if it,
The easement of access is 20 feet wide. What I think
Whether-
can often be confused is driveway versus easement of access. The driveway, you'll never see, to the best of my knowledge, or you'll rarely see the word driveway in the regulations. They're dealing with the easement of access, or in this case, the fee simple ownership to this street. The driveways meander, the driveways are various widths. The driveways exist today. We're not proposing to change it in any way, shape, or form. The fact of the matter is, the requirement is that you have an easement of access. This property has a 20-foot easement of access to Sasko Hill Road. The McDonald home, I go on to note, can be used for residential purposes once cut, because it has frontage of 20 feet or more on an improved public street. That's the pink, if you will, here. The next sentence of the text is no more than one dwelling shall be served from such easement of access or private right-of-way, except as otherwise provided in the subdivision regulations. Well, the fact of the matter is, the easement of access serves the charred property. The charred property does contain more than one dwelling, but this state of facts, number one, has existed since 1986. Number two, it's been approved by variance in zoning compliance. I attached as Exhibit A zoning compliance at the back. which shows an application for a certificate of zoning compliance in the very name of Chard, dated May 15th, 86, for construction of a one-story ranch. It shows the second page, it delineates one-story ranch, raised deck, and then there's a map included, which you'll see if you unfold it. It's labeled Map of Property for George E. and Magdalene E. Greika, dated May 3rd, 1985, and it includes a stamp, approved for zoning compliance, referencing a one-story ranch, signed by Peter Marsala, zoning enforcement officer, June 18, 1986. So the Chard property was approved, and you can see on this map the two homes are staring you in the face. It was approved with 2 residences on it back in 1986.
Was this in the record before tonight?
No, it was in town hall before.
It wasn't in the file for this application?
I do not believe it was.
Would you consider this new evidence?
That becomes the eye of the beholder, I suppose, Commissioner Wagner. I mean, to my way of thinking, new evidence is an expert report that you haven't seen, something on an issue that hasn't been raised. This is sitting in town hall. I referenced it in my comments that it had been approved by variance. This is just my way of finding some documentary evidence to support my argument. I suppose you can argue it's new. It's not.
You consider it a new illustration. It would be considered a new illustration of which you've already referenced. Is that
Correct.
what you're
I think that's a fair description. If the second sentence of my analysis also notes that the McDonald property, which has frontage on Sasko Hill Road, contains 2 dwellings. As I outlined earlier, that state of facts has existed from approximately 1927 per the assessor's records prior to the enactment of this section of the zoning regulations. The continued text of section 2.7 states the required 20-foot easement, the required 20-foot frontage or easement or private right-of-way shall be of such character and location as to provide a safe and practical means of access to the lot, to permit a convenient driveway across said frontage or easement or private right-of-way into the lot, and to allow the physical construction of a driveway of at least 10 feet in width. As I point out in my analysis, I believe this section applies to a proposed driveway. The language, when you talk about permit a convenient driveway, to allow the physical construction of a driveway, I submit is clearly prospective in nature. The driveway serving the McDonald home and the Chard property is already in existence. It's been in existence for decades. And it will continue to serve these properties in the very same manner. Common driveways, such as that existing here, are often utilized to access rear lots and have been required by the Planning and Zoning Commission under certain circumstances. I actually referenced in the very back in Exhibit B an approval of the Duck Farm subdivision, and you'll note in paragraph condition of approval 6 of the Commission's approval, it states lots 16, 17, and 18 shall have a common driveway access to Hill Farm Road to reduce traffic conflict on this portion of the road. My point is that the use of common driveways is not at all unusual, and in fact, as you'll see from Mr. Peturla, has been utilized time after time after time. The next text section says, if the location or character of such frontage, easement, or private right-of-way is such that an inland wetlands permit or a special permit for excavation and fill will be required to make use of it for driveway purposes, the Commission may require that such permit be obtained before the requirements of this section are deemed satisfied. Again, I would submit that that clearly is prospective in nature, relates to the construction of a new driveway. This driveway already exists. There's no wetlands. I think this sentence is immaterial to what we're proposing here, since it already exists. The next sentence on page 8 is a recitation of the access section of the zoning regulation. This is essentially the same language as section 2.7. It does go on to state that no walk or driveway shall be permitted giving access to any business or industrial use or district. There's no business or industrial use proposed here, and the last two sentences mirror the remaining provisions of section 2.7, which I just went through. We then proceed to the subdivision regulations, which were outlined for you by Attorney Green at the last meeting. The first section is section 2.1.1.5, which defines a rear lot. Again, no frontage on an improved public street, or which, if it does have such frontage, is not of such shape that some portion of the square is located within the area required for setback from the street. It does specifically note that rear lots shall be permitted only in residence AAA and AA. Fact of the matter is that we're in residence AAA, so under the terms of this section, rear lots are clearly permitted. The last section to be analyzed is section 2.1.1.6. I did this again on a sentence-by-sentence basis to make sure that it was clearly addressed. It first states the term access way shall mean a private way for vehicular traffic serving no more than a single interior residential lot. I think what we have here, that definition is applicable to both the 20-foot easement serving the charred property and the 20-foot right of private way owned by Lot 1 in fee simple, which serves Lot 1, which runs alongside the charred easement. These two strips, as I outlined for you earlier. The next section, next sentence states that if the 20-foot access way is sufficiently distant from a public street to make fire protection or any other public service to the home site difficult, then the access way shall be graded in accordance with the construction plan and profile approved by the town engineer. Again, I would submit that this sentence is applicable to the creation of a 20-foot access way, and your review of that access way at the time of its creation, it's inapplicable in this instance. The access way already exists. It's been approved in its present configuration by the P&Z, if you look in that Exhibit A. And the proposed new home on Lot 2 will have its own driveway, will not even utilize the access way, making any analysis of the access way neither necessary nor appropriate. The next sentence talks about the specific construction requirements. It deals with the subbase and such improvements shall be made along the entire length of the access way, shall be at least 16 feet in width. Again, these provisions apply to the construction of a new access way. The access way has been in place for decades. It's been approved by this commission on that zone compliance. But in the application at hand, no access way construction is proposed, no change in the configuration or use is proposed, and again, the new lot will not even utilize it. So, and then you see the Exhibit A that I've attached and Exhibit B, which I've gone through. At this point, Mr. Chairman, I'd like to introduce Mr. Michael Baturla, a professional engineer and registered land surveyor with the Huntington Company, just to show various examples of rear lots and common driveways in the residence AA and residence AAA zones here in town. Michael.
If I may, Mr. Chairman, just once again, I'd like to note my objection for the record, I suppose, in that it appears that the applicant is offering new materials that I and the public have not had an opportunity to review. They're first appearing at a public hearing when the chairman made it clear at the last session that there would be no new material permitted. I would also submit that Attorney Fitzpatrick indicated that this was just a recitation of the regulations in the subdivision regulations, when in fact attached to that recitation are in fact new materials relating to development on Duck Farm, which I'm not familiar with, nor have I had an opportunity to investigate. So I would suggest that the rules of fundamental fairness would dictate that this application be held open to allow me and to allow the public a full and fair opportunity to address the application. Thank you. Mr. Petrola?
I agree. I agree.
Mr. Chairman, members of the commission, my name is Michael Batola. As Attorney Fitzpatrick said, I'm a licensed land surveyor and licensed professional engineer, member of the Huntington Company with an office here in Fairfield. On the several pages I just handed out to the commission, the first sheet is our proposed subdivision map. It shows the two 20-foot strips adjacent to one another and a one driveway serving two different properties. The second sheet that you have before you shows 3 lots, 3 lots off of a subdivision that was approved back in 1996. It shows 1, 2, 3 lots serviced by one common driveway. The next sheet in front of you shows 3 more examples. One is off Hill Farm Road, and the other 2 again are off Sherwood Farm Road, showing at least 2, and in 2 other cases, 3 houses utilizing the one driveway. And what I did on the rest of the sheets, I went through and collected information from both the assessor's map, and also the following sheet is the subdivision map that represents the particular subdivision, showing examples of adjacent 20-foot strips of property and in at least serving at least 2 lots, and in some cases 3 lots. And there's 5 more examples of a common driveway serving more than 1 lot. And again, with the 20-foot strips stacked side by side. This was brought up last week in last meeting, and some, not confusion, but some questions were brought up, and it's the reason we put this together for you today.
Thank you, Mr. Petro.
I have a question.
Hey, Commissioner Wagner has a question, Mr. Petro.
Thanks. So if we could look at
I had the mic up.
Sorry?
if we could look at the chart of the subject application?
The first one.
Yeah.
Yep.
Give me the pointer. Can you give me the pointer?
Pointer, absolutely.
So, I think I understand that the boundary of the pink
Yes,
and the yellow
yes,
is the legal limits of the right, the easement and the property line. Is that
no.
is that right?
No, that's not right. The property line for McDonald's property is the combination of the two. Over the yellow portion of McDonald's property, there exists a right-of-way that goes to Chard.
Uh-huh.
Okay, so McDonald owns title to the property, but Chard has a legal right to pass and repass and
to
for utilities.
To the top 20 feet.
That's correct, the yellow.
Right.
Chard's right over McDonald's property is what I have outlined in yellow.
Right. And then the,
And McDonald owns 40 feet, but what I'm trying to depict here is there's at least 2 independent 20-foot access ways. But indeed, McDonald's property is 40 feet wide.
right. Now, depicted on that drawing
Yes.
is a single
That's correct.
road, correct?
A driveway, yes.
Yeah. And
It runs plus or minus down the center of this right-of-way line.
right. So, as depicted on that drawing, a car traveling to the Shard property would have ostensibly half its car on the right-of-way easement and half its car
That's correct.
on
That's
the
correct.
McDonald property.
No different than the 5 quick items that I picked up to show you this evening. There are many, many, many more in town.
Well,
There-
I'm not, frankly, looking at other properties or
Okay.
what has happened perhaps years ago. I frankly don't know whether any of those applications had any argument on this point, or whether any of those applications had a specific request for a waiver, or a special exception, or some sort of regulatory relief that was granted, such as the special conditions that were just mentioned by, just mentioned earlier. So, you know, what happened previously, we might have occasion to look at, we might not, depending on circumstances. I'm just trying to understand exactly what's being depicted and what's being proposed here. So I think that as it's depicted, there is a single driveway, which is going to provide access all along the upper portion of the property, and there's going to be an entrance to the McDonald McDonald home,
That's correct?
and there's a little circle there, right there, so that
Yes.
a car can actually sort of pull in and pull out.
Yes.
And it looks like the driveway goes off to the right as well there, so that,
Yes, there's a parking area in here. There's
yeah,
in front of the
so,
house,
so,
on the north side of the house.
right, so a car could pull out there and go down the Shard property as well, right?
That's
Go
correct.
down to the Shard property, I should say.
That's correct.
So, so at the end of the day, we're taking a technical review of the top 20 feet here, segregating that out from the next 20 feet, and saying those are legally separable, and therefore the McDonald property is not being serviced by the same access way?
No, this driveway has serviced McDonald or their previous owner in charge since at least 1985. At least. At one time, it was off property, this whole hill, but most recently, as I remember, McDonald's piece included Chard's piece. And this was a service for that small stone house. So it was all part of this particular estate.
Okay, so, can I, I'm sorry, you want to go?
Yeah, I guess that's the question, is there going to be there's not going to be any sort of defining line
No,
or separation
no.
between these two?
No, this has existed for 2 properties since 1985.
Your point is...
And our
Yeah, Joan, I think, okay, so the point is that right now, since the newly created lot is going to have its entrance point right there on Sasko Hill.
That's correct.
And that's set, what you're saying is you've given us these examples of where 3 homes have been serviced by 20-foot spaces to give access. And there's a number of these, and rear lot doesn't come into, at least in the view of the argument being made by Mr. Fitzpatrick, rear lot doesn't come into this discussion because AAA allows for rear lot. So if AAA is satisfied, if rear lot is satisfied, or concerns about rear lot is satisfied because of the zoning, and if indeed these kinds of configurations, we'll see if there's a counter to that, but if these kinds of configurations have been allowable throughout town, that is 3 properties being serviced by this one access point, you believe that then it satisfies your concerns of the commission regarding the legal requirements. That's
correct. Okay. If I might address Mr. Wagner's point for 1 second. When you look at the section 2.7, it says, "No lot shall be used, et cetera, unless such lot has frontage of 20 feet or more in width on an improved public street, or such lot has an unobstructed easement of access everywhere 20 feet or more in width." And this lot has an unobstructed easement of access, and this lot has 20 feet of, actually has 40 feet of frontage, but it has 20 feet of frontage. So
it's not that the regulation requires that 20 feet be used to access the property, it is merely that it requires 20 feet of frontage.
correct, it's not where the driveway is located.
That's thank you. That was the point.
That's the essence of it.
Okay, so it's not that the 20 feet has to be used for access, it is that the property has 20 feet of frontage.
Precisely.
And that's why you comply with the regs.
And, correct, and that's why we showed you all the other examples with 20-foot strips, and they run the driveway right down the middle. I mean, it makes perfect sense. You then landscape the sides, you put a road maintenance agreement into shape, you know, it's commonplace. If there are no other questions...
Commissioner Neely, I think
Yes.
has a question.
It's not really a question, what I'm just clarifying the fact that I think what you're trying to show us is that each property, both those properties, have a 20-foot access from Sasko Hill Road.
No.
So there's more than enough space
That's what we
to
that's
have
what we just
access
clarified.
for both of those rear properties, plus the fact that the new lot will have its own access. So I don't understand, you know, what the issue is, because there's more than enough room for both those properties, rear properties, plus the front property. Is that correct?
That's correct.
Is there any other question by any member of the commission?
Mr. Chairman, before I conclude, I don't think it makes much sense for me to conclude if you're going to continue the public hearing. So I'd just like to have a ruling from the chairman.
I assume Attorney Green is going to raise again your earlier motion that this matter be continued?
That is correct.
And what I intend to do is, you know, there was a statement made that it's in the eye of the beholder, and I get to be the beholder tonight.
Correct.
And while I agree that you began by presenting us with a written argument, which I don't consider new evidence, and I appreciate your written analysis of the regulations section by section. That clearly is not new evidence. However, when Mr. Peterla began testifying, we have 12 new maps in front of us, 12 documents highlighted by Mr. Peterla, compounded with his testimony. I think we crossed the line into having new evidence. And whenever either a member of the public or, in the case of this, you made the request at the last hearing for additional time to look at new evidence, I always think that this commission should err on the side of caution so everyone has their day in court, if you will, and has an opportunity to look at the evidence and comment so we can have a fair, open, and public hearing. So it is my intention to continue this hearing, so I'll allow Attorney Green, if you'd like to comment now. If not, you can look at the documents and comment perhaps next time when we come back.
I would ask to comment at the next session with respect, or next section of the public hearing on this application.
And that's fine. We'll begin with you, Ms. Attorney Green. However, there may be other members of the public here who are prepared to comment tonight. I will allow you the chance now if you wish to, just cautioning you that you can only comment on the limited scope that's been brought up by Attorney Fitzpatrick in his redirect testimony and evidence tonight. So is there any member of the public who wishes to testify only as to the redirect? And again, if a member of the public is not prepared tonight to testify or to comment regarding this scope, we will allow it in 2 weeks when this matter is put over for any member of the public, not just Attorney Green who wishes to comment. Again, you're restricted to the narrow issue which has been raised tonight, of course. So that being said, before I continue, I think Attorney Barrett's had a question to staff on this.
Yeah, I do. I have a question for staff, and I'd much rather ask it in the form of a public hearing while people, just in case it's, you know, so the applicant can hear it. But just from a zoning perspective, I drove down the driveway, and regardless of the 20-foot, it's very, very narrow in the back. Sort of like, if you could just give us either now or at the next meeting, or somehow in writing the history of this, how did this come to be placed from a zoning perspective with the McDonald property, with 2 buildings and a driveway, and then the Charge property with 2 other buildings and a driveway?
That was presented earlier before you walked in.
Okay.
It's part of the packet of stuff that you received.
Oh, it is? Okay, I'm sorry.
There is a waiver.
Okay.
And also there's zoning compliance.
It's in this document
Maybe
here?
Attorney Fitzpatrick could provide a copy of that package.
Okay, I wouldn't have read it yet anyway, it doesn't, I mean, it's, okay. No, it doesn't have to, if it's in there, that's fine, I just want to make sure that there's evidence so I could at least study how that arose.
He does not have a copy, but you
I personally don't have a copy, but you
I'll
don't have
get
to
you
answer
one
the
right
question
now.
again, I'll read it, thank you.
Thank you. That being said, I will now continue this matter, specifically 893 Sasko Hill Road, for public hearing in 2 weeks. We have one other item on public hearing this evening, that being 452 Brookside Drive, subdivision application of the Benevolent Protective Order of the Elks, number 2220 Incorporated, for 3 lots and an A zone, which is continued from January 22nd, thank you, 2013. Attorney Gelderman. Give me a second, you can set up. Yeah, absolutely. We will stand in a brief 2-minute recess while Attorney Gelderman sets up for this hearing. Okay. You all set? We're back in session. Again, this is the February 26, 2013 meeting of the Town of Fairfield Town Plan and Zoning Commission. We have one final item on the agenda for public hearing tonight. That is 452 Brookside Drive, subdivision application of the Benevolent Protective Order of the Elks, number 2220 Incorporated, for 3 lots in an A zone. This was continued from January 22nd, 2013 for 2 purposes. One, there was an outstanding question regarding sight lines, which were not depicted on any of the drawings, and there was no testimony regarding sight lines at the corner of Brookside Drive. The second was there was a question regarding the parking lot of the Elks Club building. Should the subdivision be approved by this commission, would there be sufficient spaces under our zoning regulations left in the parking lot for that building? I should note that there have been several documents circulated, and those are prepared by the staff and have been provided by the staff for our convenience. And Mr. Wendt, what are those again, so we can have that for the record?
Well, the larger of the two is just a survey we have on file showing the parking lot of the Elks Club. And the smaller is just a reduced version of that, in which I scaled the dimensions of lot 1, so you can see where the overlap is.
Thank you. Attorney Geller?
Thank you, Mr. Chairman. And that's what is up on this board, are the 2 maps that Jim handed out. The first is the larger that shows the entire parcel. As it was approved, there was a building addition done in 1987. And as part of that review process, the Planning and Zoning Commission had requested, and it was a site plan requirement as well, a layout of the parking. And the building is in exactly the same condition with the same use as it was in 1987. At the time, in 1987, there were 59 spaces. It was determined at the time, in 1987, that 44 spaces were necessary for to meet the regulations in effect in 1987 for the Elks Club. So they had additional parking, they had extra parking there. The Lot 2, if it is approved, will eliminate a total of 11 spaces, so there'll be 48 spaces on the Elks Club property if the subdivision is approved. So it requires 44. There will be 48 spaces at the Elks Club. And I didn't know if there were any questions about that.
Commissioner Jacobs?
You were just stating that when that map was originally filed, it was assessed that 40, how many spaces were?
44.
44. How about today?
It wouldn't make any difference because it would be legally non-conforming. Actually, I did a calculation slightly different from the one that Jim did, and I was a little more conservative. I came up with 48, but the correct number is 44. And whether the regulations required 150 or 2 right now wouldn't make any difference because it was approved with 44 spaces, for 44 spaces. So it meets the approval that was given in 1987. So if it didn't conform today, and it does, by the way, but if it didn't, it would be irrelevant.
When you reduce the number of spaces, you're still going to have how many?
48.
So you'll have 48 spaces left after the others are lost to...
Correct. There were 59. We'll lose 11. There'll be 48.
And
44 are required.
Under the square footage today, how many are required?
Well, as I said, I did a slightly different calculation. I came up with 48. So I was a little more, I used probably some space that might not have been calculated back in 1987.
I think the question is a little different. I think what Commissioner Jacobs is actually asking, if you utilize today's regulations, how many spaces would be required for the building on the Elks building?
The regulations haven't changed from 1987, so with respect to parking for these uses. So it would still be 44.
There. Yeah.
Mr. Wendt, I think, has a comment on that.
I was going to ask
Thank you.
what his calculation was and what the distinction is here.
There's 2 main rooms in the Elks Club. And for the purposes of the application that was made in 1987, they being the club and the commission, took a worst-case scenario. Clubs and assembly halls have a parking calculation of 1 space for each 5 persons maximum capacity. And at the time, that was, and that hasn't changed, because the additions that were made were not capacity additions, they were, you know, ancillary storage and other service capacity types of things. There was a assembly room which had a requirement for 20 spaces, and then there's a lounge or bar that was calculated at a patron and table and chair count, but those two are really mutually exclusive. Under the regs, you take the worst, you know, the large assembly space at 1 per 5. They combine them to create a worst-case scenario of the 44 spaces. So we're confident that had this club been proposed to be built today, that 44 would be the count.
And what extra space did you use in your conservative estimate of 48? Just curious.
I calculated some patron floor area in the bar. And there's a bar and with a little kitchen in there, and then there's a room with some pool tables.
Right.
And I counted all of that as patron floor area, as if it were a bar.
The other, there was another office space that you were including.
Right.
that
Correct.
that we did not need to include, because that's accessory space to the assembly space, which is the driver for the parking. How many folks can you get in there? Divide by 5. That's what our parking regs require.
And how many people is the fire code, the like maximum
I don't know what it's
capacity?
rated for fire code.
Oh, well, how do you determine how many people you can
But
get in
by
there?
the number of seats.
By the
It's
number of-
one per 5 seats. There was
I
a
see.
seat capacity, which I don't recall what that was. There was a seating capacity in each of the 2 rooms divided by 5, totals 44 spaces.
About 100.
It's, you know, it's around 200. It's not a big space.
Well, 50.
Okay, thank you.
So if there are no other questions, I can move on a little bit to the other issue, which was sightlines. Just need to get these off of here. And Jim, I don't have to put this in the record. It's in.
Yeah, that's what he said.
The next map, Mr. Chairman, I have a few copies here. I'm not sure how many. It was done by Ron Achman, our engineer. I'm not sure how many he gave me, but I'll pass them out, and it will be reflective of the next map on here.
This is the new map?
Yes.
If there's any member of the public, I'd suggest, who wants to look at the map, you can feel free to come up and stand. Why don't you leave one on the table for the public to look at? One of them will be left on the table in front if any member of the public wants to come and take a look at it. You're welcome to come on.
And there's a couple more if anybody needs. What are these lines? What are these straight lines?
That's SSMH. Folks, what I'm going to do now, I will have Attorney Gelderman begin, and just to the members of the public, let's let Attorney Gelderman do his presentation. I know this is a new document submitted. I'll give you the opportunity when you're done to either comment on it or, if necessary, request time to have that reviewed, just like we did with the last hearing. So don't be panicked, you know, that there's a new document here that you have to respond to immediately. And again, while it's being presented, if any member of the public wants to stand behind the staff to look so you can see the board, feel free to stand up there as well. Attorney Gelderman.
Thank you, Mr. Chairman. There's really not a tremendous amount of new information on this piece of paper. The first thing I would point out is, as you drive down Sant Mortar Road in this direction, which I guess would be northerly, there's a stop sign at the end of this portion of Sant Mortar Road. So Mr. Achman did a calculation from that stop sign bar. There's a bar painted on the road. The first calculation he did was to take a look at that and then go in this direction and he had a clear view for 285 feet to that point from the stop sign that's there. He also measured from each driveway 10 feet in from each driveway, and there's a little graph up at the top that shows each distance that he had in either direction, one going north, one going south from the driveway. When I asked him about, because I think this was one of the questions too, would the sight line of the location of this house have any impact? He said, well, the primary thing that's going to happen on this is there's going to be a grading and a sidewalk put in. It's actually going to improve the sight line at Sant Mortar going left as you're coming down in a kind of northerly direction. But more importantly, he said there's a stop sign there. So really the sight line from Sant Mortar to Sant Mortar doesn't really become an issue until you get down to the stop sign, because in theory at least, however fast you're going, you're supposed to stop there. And so the car becoming visible whenever. But the bottom line also is that this portion of the lot, the northerly corner of the lot, will be cleaned up, lowered, and will actually improve the sight line from this part of Sant Mortar to this part of Sant Mortar. But again, I don't think it makes a whole lot of difference one way or the other, since cars have to stop here. So that's why he measured this line as well, and there's a 285-foot sight distance from the stop sign in this direction. What happens is there's a slight change of grade there. That's why it stops at that point. And, you know, just for the record, I would point out to the Commission that there are no regulations that you have that define sight lines except with respect to new roads. You have a new road provision.
Commissioner Barrett, I think it's a
Yeah, actually we have had driveways as sightlines, I believe.
And
I believe our regulations say that sightlines need to be adequate as determined by the town engineer. It does apply to driveways.
Well,
we have
adequate is not much of a standard. I don't know
No,
what
I mean,
distance
well,
that is, but...
there's all sorts of industry standards. For instance, for road intersections. For example, my question to you specifically would be the southerly sight line. That's looking out at either of these driveways south, which is towards that way, towards the right side of the map, right?
Yep.
It's 200 feet.
200 plus feet.
Right,
Right.
and that's just a number. We usually see evaluated in terms of what is the average speed on the road, the 85th percentile, and determine that, because there are published stopping sight distances and intersections. In other words, somebody pulling out of that driveway and turning left, is he going to be able to see the cars quick enough to properly exit his driveway? And that's what we're looking at, is the safety of ingress and egress. And we have had as you'll tell us later in your summation, subdivisions is an administrative hearing and we evaluate against our regulations, but safety and proper ingress and egress is is a legitimate concern of our commission. And that's why we ask that, not just to be difficult. We want to make sure that people leaving the site and entering the site will be able to do so safely.
And that's fair, and that's fair. The point of subdivision regulation, I don't want to get into an academic discussion with you here because it doesn't really serve any purpose, but you could adopt regulations that provided that. And I'm going to hand in this case that I've handed in before to the commission, and you've all seen it, I think. It's the Mayor case. And it's law in this jurisdiction because it wasn't appealed by the town. It was decision by Judge Radcliffe about 5 years ago already. And actually, that case had a sightline issue as well. And when you read the decision, you'll see that Judge Radcliffe said, if you have regulations that permit a lot in a particular area, if you don't have a regulation involving it, a specific regulation, not health, safety, welfare, those aren't regulations, those are standards, or those are that's enabling legislation. That in the absence of a standard, it doesn't apply, it doesn't exist. So I'll hand in this, and again, you can take it for what it's worth.
Yeah, Mr. I would just say that since then we've tweaked our regulations because of that case. And I'd also, not that I'm a lawyer or anything, but there's a case we call the McElroy case on Stratfield Road, which was subsequent to that, where they cited that, which was denied just because of sightlines. It was never appealed because the sightlines were determined not to be adequate. I'm just saying what our commissions, why we're interested in this, and we've had a couple of subdivisions denied because of sightlines, and most subdivisions don't get denied, so I'm just saying it's a legitimate interest. I believe, again, we don't necessarily debate it, I'm just saying why we're asking for this.
And again, I don't dispute that it's a legitimate thing to be concerned about. And I think the commission could adopt standards if it chose to that would let an applicant know exactly what standard it is they needed to meet.
Well,
And by the way, 200 feet is in Trumbull and Monroe, Stratford, range from 150 to 200 feet in their regulations. They have specific numbers. Easton happens to have 225 feet.
Ours used to be 225 feet.
Yeah.
And we actually changed that to say that adequate is determined by the town engineer. It used to be just a blanket 225.
And there is still, when you're talking about new roads in the subdivision regulations, from the center line. So there are standards when it comes to new roads. Obviously, we're not proposing to build any roads here.
Commissioner Wagner?
thanks. So the other side of someone coming out of the driveway and having adequate sightline is also for a car traveling on the road to be able to stop in time if a car juts out of the driveway. And so to Commissioner Barrett's point, there is an average speed of the travelers on the road, the 85th percentile, and then the stopping distance per feet and what have you. So the adequate sightlines can change from circumstance to circumstance based upon, the configuration of the roads and the contours and the grades and such. I mean, we just were considering an application, and I forget the name of the street, where the 85th percentile was like 15 miles an hour. So the sightlines were, it was Chatham Road, yeah. So, as opposed to, sightlines being required on a road where the average speed is 40 miles an hour. The sightlines would have to be greater in order to allow people to stop sooner. I'm not suggesting any issue. I don't know. I'm looking at this for the first time because it was just handed in tonight. But that's how I think it interplays with each other.
Well, yes, and I understand that's how the commission likes to do it, but all I'm suggesting is that the commission ought to have a specific regulation, and it's subdivision regulations.
But we do. This is adequate.
No, that's not a standard. That's an opinion. It's not a standard. So, and again, I'm not the town attorney. You guys do what you need to do, but I know what the law is with subdivisions, and if an applicant can't tell, you ought to be able to, for a subdivision, you ought to be able to present it to a commission or even a staff person and say, here, it meets the regulations. You got to approve it. That's pretty much the law. There's not supposed to be subjective standards in subdivisions. Adequate is kind of subjective.
Right, well, I mean, just keep, you know, our regulation in question is 2.1.4.4. That is
New
the
roads,
regulation.
right?
No, it says safe and adequate, it says intersections. Safe and adequate sightlines for particular conditions as determined by the town engineer shall be provided.
Yes, but if you go back, that section deals with new roads.
No, it's just intersections.
When you're building subdivision roads that intersect with another road, that section deals with new roads.
It just.
Those are map designs. Go back to the beginning of the section.
It just says intersection.
It says that in 2.1, but you got to go back to go back to 2.
It just says map design standards.
Yeah. We're not designing a road. That would be a map design standard.
This has been applied, it just says intersections.
It's part of a broader section.
Yeah.
It deals with new roads. You guys interpret your own regulations, but
Yeah, I mean,
That's
there's a
what it
section about
says.
street above it, but this just talks about intersections.
I know it does, for new roads.
It
Because
doesn't
that's
say
what
new
that
roads.
section deals with.
Yeah, okay.
Thanks. No, I was going to say, Mr. Chairman, I think that, you know, I think the members of the commission are familiar with the standard that they believe they can exercise, or the standards they can exercise in their administrative capacity when it comes to subdivision related to safety on site and its interaction of the site with the road, and all this kind of discussion.
I agree.
Somewhere down the line. So I would just say let's move ahead.
Well, I know that there are people in the public who probably want to speak, so I'll hold off and...
Commissioner, I like it so much.
Mr. Parker has a question. Yes, yeah, I called that.
It's on the side. You see that thing over there?
Thank you. In terms of our judgment on something like this, we do spend time at the site, and we drive the streets, and we sit at the property, and when I'm there, I'm looking at a property, I have no sense whatsoever of what the landscaping plan is, what bushes might be planted, what'll be happening there. It seems to me it's a rather hazardous situation. And, you know, I think that numbers don't define what is safe.
Well, it is a hazardous situation, and this subdivision will lessen that hazard. So, it'll improve the sightlines on that corner, not make them worse.
You're going to
I'll
finish with your presentation?
Yep.
Is there any member of the public who wishes to comment on this application? Just come on up to the podium one at a time, just give us your name and address. The two issues that you're restricted to talk about this evening, since the public did go last time, are either the traffic that we just talked about or the parking issues. So come on up. You're registered so we can record you, yes, just give us your name and address, ma'am.
Gwen Beaver, 353 Brookside Drive. And basically, I live here, okay? The woman who made the point about the traffic, I think, and I'm glad to hear that you are going to sit there, visit there, drive around there, because if you took a look at police reports for accidents here, and accidents here, and accidents here, I think they would be significant. I don't know numbers, but I live here, and so do a couple other gentlemen who live here, and the first thing I don't know these gentlemen, but the first thing we said to each other is, it's a real hazardous area. There's not only this stop sign here that is hazardous, but there's the stop sign coming down from Blackrock Turnpike that already has significant site issues with the stop sign. So when you think about people pulling out of their driveways here, God bless them, God help them. That's all I have to say, okay? The other thing I'm curious about, and I don't know if this is the forum to address this, but this is an old neighborhood. We live in a converted barn that was purchased, that was built maybe 100 years ago, don't even know. And I've lived there 23 or 24 years. My issue here is that there's another subdivision right around the corner here on Pansy and Brookside Drive. I hope I'm not offending anybody here, but it really has, I think, brought down the quality of housing in the area. We have a lot of, we have beautiful brand-new homes, we have beautiful existing structures, a lot of different sizes. I think it's a real representative community of Fairfield, and it's a lovely, lovely area. But it seemed that there was a subdivision that was happening up here, and then it stopped. And I don't know why, but I think many of us who live around there are sort of thankful that it stopped, because it really has been not in keeping with the rest of the neighborhood, and it begs the million-dollar question from a resident like me: how did that happen? Okay, how did that happen? So those are my 2 points. The third one, and I don't know if this can be addressed now, which is, what will these homes look like?
And that's something, first
I
of
know,
all, it's not something that we
Okay.
address, as aesthetics. We don't have jurisdiction over the aesthetics. They have to comply with all the town building codes and the state building code regarding the construction. They have to comply with the
I would
zoning code,
expect,
should we approve
yeah.
it, setbacks, height, coverage, things like that. But the aesthetics as to what they look like, there's no regulation that we enforce, number one. Number two, that's beyond the scope of this hearing as well.
Okay.
The two things you could talk about are traffic and parking.
Yeah. Well,
At this
I
point.
think I've addressed parking and the traffic, and I cannot imagine that this would actually enhance the traffic or the safety issues there, even with a sidewalk. Even with a sidewalk. I think to more people you put on that road, running, walking is a detriment to their safety, and I think would be hazardous to any pedestrian that was walking there. So that's all I have to say. Thank you.
Thank you.
Okay.
Sir? You got to go to the microphone because we're recording, sir, that's all.
I'm her husband, Edgar Beaver, same residence, etc. And all I wanted to say was basically coming down Sant Mortar to turn up Sant Mortar.
Which Sant Mortar? If you could show us on the map.
So, again, we live up here, and we're talking about this place here. Coming down, I guess, I don't know if it's Sant Mortar here.
From Blackrock Turnpike.
Yep.
Yep.
To turn left here, you can't stop at this stop sign here safely and turn left. Try it.
Why can't you stop?
Because
Maybe
you
elaborate
can't
on
get
what you
far
mean.
enough along to see over this hill to see who's coming up the hill. So go take a look at that before you allow anybody else to make that same mistake of pulling out of a driveway and turning perhaps left when someone's coming over this stop sign and observes the stop sign, right? They observe it because they can't see over the hill, and they take off and crash into somebody pulling out of their driveway. Just my observation.
Thank you, sir. Is there any other member of the public who wishes to address the commission? Okay, hearing none, Attorney Gelderman?
I'll be very brief. As I said earlier, measured from that stop sign to a point where you can't see very well, the hill is actually over here. It's not here. It's beyond the driveways. It's a 285-foot sight line there. And the reason that I think, it's if the situation is bad, and it's bad now, this is an opportunity to make it better. The fact that two houses are going to have driveways here isn't going to have much of an effect of people on Sant Mortar Drive going in this direction or this direction. But the cleaning out and the leveling and the making a lawn and a sidewalk in this area will improve the ability of people who are at this stop sign to see in this direction and coming down Sant Mortar. So while it's not a perfect situation now, and it probably isn't a perfect situation later, it'll be better than it is now if that lot is developed. And again, I'm kind of getting into something that I don't even particularly think is all that relevant. And again, I think that the only point I want to make is that the subdivision application here does meet all of the objective standards of the regulations. If the commission feels that they can apply subjective standards, then they'll do it. But in terms of the objective standards, lot area, square, all that kind of stuff, these two lots meet the regulations.
Commissioner Wagner.
Thanks. The line from the stop bar
Yes,
to 285, is that post-construction?
no, that's today.
That's today.
The engineer was on the site,
Right.
you know, and he had a guy standing there with the thing. So that's the distance today.
So notwithstanding whatever shrubs and brush and whatever,
Right.
as it exists today, there's a 285
There is.
foot sight line.
There is. And again, this isn't your question, but what really stops that line of sight is an elevation change.
Yeah, you're looking into the road.
Right. It's not so much this stuff, but there is growth of things here that do interfere with your view down this.
Well, as you're driving down.
Yeah.
On that line of sight, do you know from what elevation the line of sight was measured?
I think he does it from 4 feet. It's supposed to be the elevation of a car. Sitting in a car. And with that, I would just respectfully request that the commission consider this and approve it.
We're looking at a
Commissioner Leslie has a
sightline of
question.
285 feet with a car practically at a stop sign, starting from 0 and then increasing from there, not coming down already at 40 miles an hour and 30 miles an hour. There's a stop sign on that corner coming down.
Yes, coming down this way, there's a stop.
Both sides, and coming right across from Blackrock Turnpike too.
Yes.
Thank you.
Thank you.
There being nothing further on the agenda, this will close the public hearing on 452 Brookside Drive. And there being nothing else on the agenda for this evening, the meeting will stand adjourned.
Okay, so that is a